Hi everyone, and welcome to today's webinar hosted by Ciphr and our friends at Shoosmiths. It's an employment law update and for May 2025. It's great to have you with us today, and it's great to have a team of Shoosmiths who I couldn't quite all fit on this slide with us today, led by Stuart Lawrenson, who's partner and head of Southampton office, Sian Hoare, who's the legal director. We also welcome Ashley Cheshire, who's associate with Shoosmiths, and Antonia Blackwell, professional support lawyer, who's helping us with the questions and answers. Plus, we have Amanda Barnden from Ciphr, who's our sales manager, and she's just going to whiz us through some of the things we do here at Ciphr in case you're new to us. So thanks everyone for joining us. I know we've got a lot to cover today, so I won't spend too long on the introductions. We've got a packed agenda. The agenda looks short, but rest assured there's plenty of content in here. Amanda's going to give us a quick tour of what we do here at Ciphr, our software and services, before I hand over to the Shoosmiths team for a really comprehensive employment law update. If you have any questions at all, whether about Ciphr products or probably more likely around legal issues, remember, we're not giving out legal advice here. We're just offering views on some things like regulatory updates and case law. Please send those questions in using the Q&A function, and we will do our best to answer those all at the end of the webinar. We do have a lot of content to cover, so we may run out of time, but we will do our best. Remember, this is being recorded and the recording will be emailed to you afterwards, so you can revisit parts of it or share it with a colleague. And with that, I'm going to hand over to Amanda and get her out of the way. So thank you, Amanda.
Thank you, Catherine. Welcome, everyone. Thanks very much for joining. I think since you're here, you probably know who Ciphr are and what we do. So this is just going to be a really short intro, but we've got some really exciting things going on here at Ciphr. We are obviously an HRIS provider. We've got a whole range of really exciting things to offer our customers, old and new. So we've identified key trends. We talk to our customers a lot, and these are the things that you're telling us that are really important to you. So we're responding to that with our platform. And as I said, we've got some really exciting new tools. Earlier this year, we launched our cloud-based payroll. We have new AI tools being introduced. The first of those is in our performance management module. And we've got some more coming along for policies and so on. We've got some really great analytics tools and a very, very fresh new look for the whole platform. So if it's a little while since you've taken a look at Ciphr, do come and talk to us. We'd love to take you through all of the exciting ways that we can help you to support your workforce. So this is how it all fits together. So that central hub of HR data, your central payroll and HR people solution, and then all of the pieces to make that fit together that you can build on over time. So including benefits as well. Ciphr Benefits is one of our newest introductions there. So all of that comes together to help you to amplify HR. People are your people's biggest asset and your most expensive asset. So let's make sure that we help you to keep developing and retaining and upskilling your amazing teams. Thank you. I'll hand over to the Shoosmiths team.
Thank you very much. Hi, good afternoon, everybody. On behalf of Sian, Ashley, Antonia, and I, we are absolutely delighted to be partnering with Ciphr to deliver another employment webinar to you this afternoon. Thanks to everyone at Ciphr, particularly to Catherine and Amanda for the invite. I'll just repeat the comments about the ability for you all to raise questions through the Q&A function. We will endeavour to try and provide a little bit of time at the end, and we are going to deal with the questions that have been raised in advance. So without further ado, just a quick update in relation to what we're going to cover today. I think we're going to try and break a record as to what we're going to cover. It's going to be pretty full on, but we'll see what we can get through. But Ashley's going to kick off with a quick legislation update. And then Ashley and I are going to share the case law update. There's some absolutely really significant cases that have been reported in the last 6 months. And then Sian, I think Sian's pulled the short straw. She's got about half an hour to provide you all with an update in relation to the Employment Rights Bill, just the key points that are coming. It's continues to develop, continues to be amended, and us to get our heads around all the little changes and nuances and trying to understand when everything is going to come in. And then finally, we're going to deal with your questions, all in an hour and a quarter. And we're going to be finished by 3:15. So without further ado, over to Ashley for the legislation update.
Afternoon, everyone. So as Stuart's just said, I'm going to first take you through the recent changes in legislation, most of which you'll probably already be aware of, but just by way of recap. So the first update is in relation to the national minimum wage rate, which has increased from the 1st of April. If we can just go to that first slide.
Apologies, Catherine. Could you? There we go.
So the new rate for those aged 21 and over is now £12.21, and the new rates are set out on the screen now. There were also increases to the limits on tribunal awards. Next slide, please. And these are also now on the screen. The new limit on the maximum compensatory award isn't as easy to remember this year, and has increased by approximately £3,000, and it's at £118,223. The weekly rate of statutory sick pay has increased to £118.75 as of the 6th of April 2025. The weekly rate of statutory maternity pay has also increased to £187.18. The lower earnings limit is £125, but the maternity allowance threshold remains at £30 a week. Next slide, please. So as of the 20th of January 2025, a protective award can be increased by up to 25% where an employer is found by the tribunal to have unreasonably failed to comply with the new code and practice on dismissal and re-engagement. So the new code of practice does not ban the use of dismissal and re-engagement, but is instead designed to encourage employers to enter into dialogue with employees to explore alternative options first. So just a flag on this, the code will be engaged as soon as an employer raises the prospect of dismissal and re-engagement on revised terms. And so employers will need to consider the number of employees concerned, determine whether collective redundancy obligations apply when seeking to change terms and conditions. And so the last update is in relation to neonatal care. And that's the right of up to 12 weeks leave for parents of babies requiring neonatal care, which came into effect on the 6th of April 2025. And this applies in respect of children born on or after the 6th of April 2025. It's available from the first day of work and available to parents of babies who are admitted to hospital up to the age of 28 days old and who have had a continuous stay in hospital of 7 full days or more. It must be taken within the first 68 weeks after the child's birth, and it is available to a child's parent or a doctor or the partner of the child's mother or a person who has responsibility for the upbringing of the child. The neonatal leave is split into Tier 1 and Tier 2 periods, which is just set out on that next slide. Tier 1 is the period from the day the child starts receiving neonatal care to 7 days after they stop receiving the care, and leave during this period can be taken in long consecutive blocks of 1 week. The notice must be given on the first day of absence or as soon as reasonably practicable thereafter. Tier 2 is any other period where the employee is entitled to take that leave, and the leave must be taken in consecutive blocks. Notice to take a single week must be given at least 15 days before the start of the leave, and for 2 or more weeks, 28 days must be given before the start of the leave. The statutory rate of pay for neonatal care is £187.18 a week, or 90% of average weekly earnings, whichever is the lower. And so that's a whistle-stop tour on our legislation update, and we're now going to go into our case law update, and Stuart's going to kick us off with the first case.
So I think I may have pulled the short straw in this one because I've got to try and summarise the case of Higgs to you. This case is really important, reflecting the fact that we are getting lots of queries about issues relating to social media. I've spent a lot of time trying to think about how I'm going to try and explain this case to you. It's a really important case. I make no apologies for the fact that it's really, really complex. We've had updates as a firm of solicitors. I've been on a webinar that spent an hour and a half with a firm of where barristers basically just talking about this case, and I've got about 6 or 7 minutes. So I'm going to do my best to sort of try and summarize it for you. It's a case that really divides opinion. It's a case, I suppose, that divides opinion between what societal views are, and the legal position. And I want to sort of go back to, I suppose, not really some law, but some just, I suppose, broad brush overview thinking on it. And that starting point is that the reality, employees leave their personalities at home less frequently. And social media is one of the most obvious reasons why that happens. Because social media, if you think about it, encourages employees to be very open, or in fact, not just employees, but everyone to be open about their views. But the law is far more limited, particularly in the context of harassment. So social media means that views are far more likely to be expressed, and social media also means that those views are far more likely to reach an audience that's going to be upset. And sit in the middle of that is the employer. The employer's got to balance, hasn't they? The employer's got to balance protecting its own position to ensure that they're not exposed to any claims. They've got to protect the interests of its employees. And at the same time, the employer's also got to accept the fact that employees have got various rights, including the right to manifest their views. This was a case that looked at religion and belief. And religion and belief is, of course, it's a protected characteristic. And an employee can complain if they're subject to a detriment because of religion and belief. Generally speaking, again, a broad brush statement is that employers don't care what religion an employer has as long as they keep it to themselves. It's only when an employee outwardly manifests their belief do employers, I suppose, start to think about whether or not they want to take action about that. Now, the issue here is that the concept of direct discrimination isn't really geared up to deal with manifestation. There's lots of commentary about issues with direct discrimination in the context of, say, disability discrimination, and the fact that actually that provides little protection. And why is that? Well, that's because of who a comparator is in the context of a direct discrimination claim. And that's why, in reality, we've got all of the other different types of discrimination laws in relation to disability that provides adequate protection to employees. In the context of religion and belief, the question that needs to be considered is, am I being dismissed because of my beliefs, or am I being dismissed for manifesting them? Because at the heart of the protections in relation to this is not only the right to hold those beliefs, but also to manifest those beliefs. And the key here is that if an employee can bring a manifestation claim as a direct discrimination claim, where does that leave an employer? And that's the reason why that's so tricky, is because you can't defend a claim of direct discrimination. So the question that this is given rise to is, does that mean that all forms of manifestation are okay? And if not, where do you draw the line and how do you do so? So there's lots of cases that have been seeking to explore that, and Higgs ultimately tried to bring that together. Higgs was a case about a staff member at a school. You may have seen it reported. She was Christian and she was in charge of pastoral care. She made posts on social media about government policy, about what kids should be taught, about homosexuality and gender identities. The Facebook posts focused on her disapproval of the teachings of gender fluidity, and they concerned her opinions regarding her not being happy that children being taught that all marriages are equal and all relationships were equal, and that they were taught that gender was a matter of choice. It's worth mentioning that these weren't actually her own posts. She was basically forwarding the posts and commenting on them. The posts were in her maiden name, not the name that she used within the school. The posts only landed with 100 people. The language was pretty inflammatory, and in this case, the parents complained and she was dismissed. And the Employment Tribunal said her beliefs were not the reason for dismissal, and there was no discrimination. The EAT, I'm just going to skip over these very quickly because it's the Court of Appeals decision that's most important, but the EAT said that no, she was dismissed, and ultimately there was no disagreement that she was dismissed, but they did hold a claim of direct discrimination. And what the EAT said is they brought in tests from human rights law, in essence, basically writing in parts into the Equality Act. And they basically carried out a 4-stage test. They said what you have to think about is, was it protected? What do the employees do? Was there a close nexus? Then they applied a manifestation test, and then they applied a justification test, which goes against what is written within the legislation. So we got to the Court of Appeal, and that's the area that I want to focus on because that's the one that's been reported recently. And the Court of Appeal said, we've got to have a prohibition of direct discrimination on the grounds of manifestation. They said, yes, it is a direct discrimination claim. The Court of Appeal was happy for there to be some rewriting of what the legislation actually says. And they were happy for there to be some objective justification because they say you've got to have some form of defence to these sorts of claims. Before I get into the commentary on that, I just want to talk to you about what the outcome of the case was. In relation to her actual claim, they said, was it inevitable that there should be a finding of direct discrimination? They said yes, and that was despite the fact that she'd reposted and despite the fact that she'd added to those comments. They said if the Employment Tribunal had applied the test correctly, they would have found that it did amount to direct discrimination because they said it wasn't grossly offensive. It wasn't her own post. They took that as being something that was material. The school had overly relied on reputation. And there was no real belief that she was actually going to do anything with the comments that she'd expressed. So the reality of the situation is that we're now in a bit of a mess, I'm afraid. What the courts we don't think will do is look favourably on any employer where there is a knee-jerk reaction. Again, a bit more detail in relation to this case. This was on a private social media account. I've made mention already about the fact that she was using her maiden name. There was no reference to the school. There's no reference that she'd actually expressed these views when she was actually in school. And there was no evidence that she was going to. It was deemed to be offensive, but it wasn't deemed to be grossly offensive. And there was no evidence of reputational damage. So from an employer's perspective, I'm afraid this leads us in a tricky situation, tricky position if you're ever faced with one of these cases, because you are potentially going to be on the hook if you take action for the way in which an employer has manifested their beliefs. This isn't a case where there'll be a range of reasonable responses. That's absolutely not the legal test that will be applied. But taking into account what the Court of Appeal has said about the fact that you can justify it, this is going to come down to a question of proportionality. We haven't got any guidance on that. So unfortunately, the frustration that we as advisors are at the moment is that this is going to come down a little bit to the judge that you're in front of on the day. So it's a really, really important case. If you do come across these sort of cases that land on your desk, please make sure that you're aware of this case and of the real difficulties of defending them and the unpredictability about how they might be determined at tribunal. Ashley, over to you.
Thanks, Stuart. So the next case is Carosi against the University of Herefordshire. Mrs. Carosi was an employee of the university. She was of Brazilian nationality and Jewish ethnic origin, and she had a very strong accent. So this is a case to do with her dismissal, and following her dismissal, she brought claims of harassment on the grounds of race, because she held that she had been dismissed because of her very strong accent. There was a comment that was made to her as part of her probationary review meeting, and the feedback that she was given during this meeting was that she had a very strong accent, and quote, "Although your English language is very good, it can be difficult for you to be understood. And this is an issue when your role is one of communication, engagement, and partnership." And she equated this comment to be a discriminatory comment based on her accent because of her Brazilian nationality. Now, the definition of harassment is where somebody makes an unwanted comment connected to or on the grounds of, in this case, race, and it has the purpose or effect of creating an intimidating, hostile, degrading, humiliating, or offensive environment for that individual. Now, Mrs. Carosi was arguing that this comment did do those things and did create that environment for her. When the University of Herefordshire were defending the claim in the first instance in the Employment Tribunal, they made the point that the comments made in that review meeting weren't motivated by the claimant's race. But the issue they were having was that she struggled with communication and being understood as a result of her English language being her second language. And she'd actually admitted herself that in the course of her employment. So Mrs. Carosi knew she'd got a very strong accent, and she'd even referred on a couple of occasions to having elocution lessons to help her to understand and speak more clearly. So one of the key things to be aware of as a result of this case is that comments made about an individual's accent can be related back to their race. And so criticism of an accent could violate someone's dignity. However, this does not mean that any mention of a person's accent will amount to harassment. So, whilst the Employment Appeal Tribunal has given some helpful commentary in this case, it has been remitted back to the tribunal to make a fresh decision. And so, this case is a very much watch this space in terms of the ruling that might come out of this again from the tribunal when it's considered further. So, in relation to this case, and I think it's really important to bear in mind that when somebody brings a claim of harassment and tries to establish whether a comment created that intimidating or hostile environment for them, it's the individual employee's perception that is taken into account originally. However, the question that is then asked on the tribunal is, was that reasonable for the employee to feel this way? And I think this will be an interesting case to watch when it comes out of the tribunal, because Mrs. Carosi has obviously admitted herself that she's got a very strong accent and she was difficult to understand. She had also attended elocution lessons, acknowledging that there was some improvement needed. And so, was it reasonable for her to feel that this comment made to her in her probationary review meeting was unreasonable and also created that offensive environment in these particular circumstances? So, this is a case we'll just have to watch this space and see what comes out from it further. I'm now passing back to Stuart to talk about our next case.
Okay, I'm going to touch a little bit later on about what's landing on our desk, but let's just say our current instructions involve, unfortunately, dealing with quite a large number of redundancies and restructures, both small scale, large scale, quite a lot of them on the back of the hike in national insurance contributions. We're getting lots of queries about the protections afforded by Regulation 10. I'm not sure whether that's just coincidence on the back of the extended protected period. So this first case actually looked at Regulation 10, involved Carnival against an individual called Mrs. Hunter. And Mrs. Hunter had been on maternity leave, and this looks at the application of Regulation 10. Regulation 10 is, of course, the regulation which gives employees on maternity leave priority for any suitable alternative roles that exist over and above anybody else who is at risk of redundancy. So what were the facts of this case? Mrs. Hunter was one of 21 contact centre team leaders that Carnival had in place. And within that specific team, Carnival decided that they needed to reduce that team from 21 down to 16, so a reduction of 5. All 21 were put at risk, and they went through a scoring process to work out essentially who are the top 16, who should be retained, and which 5 should be then made redundant. Mrs. Hunter fell within the bottom 5 after the scoring process, and she brought a claim and sought to argue that Carnival hadn't applied Regulation 10 in the correct way, and she said that had they done so, she would have got one of the 16 roles that were available. Now, if we had time, I'd do a quick poll to see what you all think about whether or not you think, other than the Regulation 10, she should have been protected and been guaranteed one of those 16 roles. Unfortunately, we haven't got time to do a poll, but if you did, and if any of you had said yes, I'm afraid you've been wrong, because this case has confirmed that in this situation, i.e. a situation where you've got simply a number of roles that are reducing, Regulation 10 does not apply. The only time that Regulation 10 comes into play and where you need to give priority to an employee on maternity leave is if a new role is being created, not if you are selecting from current employees and reducing the number of employees performing a particular role. In this case, as the 16 roles were not changing, they weren't deemed to be suitable alternative employment, and therefore Regulation 10 didn't come into play. Now, obviously, in this situation where we've got a reduction down from 21 down to 16, Carnival had been chosen. The 5 would then have to have considered employees for any vacancies that were existed. And if any vacancies were, then Mrs. Hunter would have had priority in relation to those. In this situation, there wasn't any, and therefore Regulation 10 never came in. Before moving on, I've just, as a matter of interest, and on the basis that we have had not 1, but not 2, but 3 questions in relatively short term on exactly the same point, I just thought I'd add to this case. And the question that's been asked of us is whether or not the Regulation 10 provisions and this protection applies to suitable alternative employment or to alternative employment. I'm sure you'll all be aware about the subtle differences between the two. And the answer to that question is that the protections only apply in relation to suitable alternative employment. Why does it do that? Well, that's when you have to get the law out, I'm afraid, and you have to read the fine detail of Regulation 10. For those of you who want to look it up, it's actually paragraphs 2 and 3 underneath Regulation 10. Both of those paragraphs make reference to suitable or available vacancies, and all of the commentary in relation to this confirms that it only relates to suitable alternative employment, not to alternative employment. So a lot shorter case, that one for me. Back to Ashley, who's going to deal with the next case.
Thanks, Stuart. So the next case that I'm going to be talking to you about is the case of the Banks Haycox and ADP. It's another case that concerns redundancy, and one which has made it all the way through to the Court of Appeal, who have come out with, I think, some reassuring comments in terms of potentially remedying issues with the consultation process once it gets to that appeal stage. So, as a reminder, then, for a redundancy dismissal to be fair, an employer must warn and consult employees when proposals are at a formative stage. The employee must have enough information and time to respond, and the employer must give genuine consideration to the employee's views. So, Mr. Bank Haycox was selected for redundancy. He was one of 2 people that were selected, and the company had gone through an individual consultation process with those 2 people. He had scored the lowest, but he was not given his score before he was dismissed. So, as mentioned, this was remedied at appeal. Mr. Banks Haycox appealed against his dismissal on the basis that his consultation wasn't meaningful, he hadn't seen his scores, and he hadn't been able to comment on those, all of which was rectified at the appeal stage. And he was given a full opportunity at that appeal stage to put forward his comments. They were considered at the appeal, but his dismissal was still upheld. So he then brought a claim for unfair dismissal, which went right up through the courts and got to the Court of Appeal, who have made this judgment. So the issue here was whether a fair consultation requires general workforce consultation, even if statutory collective consultation requirements do not apply. The Employment Appeal Tribunal had suggested that it does, but the Court of Appeal overturned this decision and said that it did not. So the Court of Appeal, in making this decision, have made some interesting comments in terms of taking into account that ADP, the employer, was a relatively small business. So there wasn't enough redundancies or enough employees to trigger collective consultation. So this was very much a kind of tailored, individual, small-scale redundancy process. And the tribunal took that into account when considering whether a thorough consultation had been carried out, and came to the conclusion that, including the appeal, a thorough consultation had been carried out in choosing to make Mr. Banks Haycox redundant. And I think this is quite reassuring for employers, because in an individual consultation like this, if they do make a mistake, then it does have the ability to be rectified on appeal. However, that said, we would still absolutely advise that if you're going through a redundancy consultation process and an individual redundancy consultation with an employee, you do give them their scores and the opportunity to comment on those scores before you dismiss them. And this is because although this case is a fallback if you need it and a mistake is made along the way, best practice is going through that process with the employee at the initial consultation and before you make any decision to dismiss. And so it's important to remember, however, that whilst there are established best practices for conducting a fair redundancy process, and this case very much helps as a useful reminder of those, the fairness of any specific redundancy dismissal will always depend on the individual facts of the case. And so I'm now passing back to Stuart to talk about his favourite case.
I'm not sure if it's my favourite case, but it's the second big one from me. I'm going to try and tackle For Women Scotland. It's the second significant case of the session. It's one of those cases that's just exploded, hasn't it, as far as press coverage is concerned. I'm not going to go into the facts of the case, other than the headline comment of the fact that the case has determined that sex means biological sex for the purposes of the Equality Act 2010. I think it's fair to say that everyone is still very much digesting the decision, and the EHRC, which is of course responsible for providing guidance to policymakers and businesses, were under some pressure to issue something post this decision, and they did so. They provided some interim guidance late on Friday the 25th of April, and I want to go into that guidance, if I may, in the short time that I've got today. So the interim guidance aims to provide an immediate explanation of the judgment and to reassure service providers that further guidance is coming. I, like many, of the view that further guidance is desperately needed. And unfortunately, the position for many employers remains unsatisfactory. The interim guidance reiterates the outcome of the case, namely that a woman is a biological woman, so someone who was born a female. A man is a biological man, so someone who was born a male. And a person who identifies as trans or who has a gender recognition certificate, often shortened to a GRC, does not change sex for the purposes of the Equality Act. The impact of the case is far-reaching, particularly in the context of employers and service providers that are open to the public and provide things like leisure facilities, hotels and hospitality. And much of the interim guidance looks at facilities, things like toilets, washing and changing facilities. And I'm going to summarise that guidance now. So in workplaces, it's compulsory to provide sufficient single-sex toilets as well as sufficient single-sex changing and washing facilities where these facilities are needed. And the guidance says that employers should not allow trans women, so a biological man, to use women's facilities and vice versa for trans men, i.e. biological women, because this would mean they're no longer providing single-sex facilities. Where facilities are available to both men and women, trans people should not be put in a position where there are no facilities for them to use, or put another way, trans people must not be left in a position where they have no facilities at all. Where possible, mixed sex toilet, washing or changing facilities, in addition to sufficient single-sex facilities for employers. Well, whilst it's clear that where a single-sex facility is provided, an employer should not allow trans people to use the facility aligned to the sex to which they identify, it does not address, and this is key, how to balance the provisions of single-sex facilities against the rights of trans people not to experience gender reassignment discrimination and harassment, in particular where there are no suitable or equivalent facilities for them. So claims are still possible because the Equality Act does not give employers protection from trans-related discrimination claims that's given, say, to service providers. What this means is, this thing stands, is there's risks of sex discrimination claims if you as an employer don't follow the recent guidelines, but there's no practical answers as how to mitigate the risks of gender reassignment discrimination claims associated from moving from what we've had until now, which is generally quite an inclusive provision. The interim guidance suggests that the provision of mixed-sex toilet, washing or changing facilities will address this challenge. And whilst this may be a longer-term solution, if equitable mixed-sex facilities can be provided, it doesn't address the practical challenges faced by employers in the short term. This isn't something that can easily be changed for many overnight. In many workplaces, particularly smaller employers, there's either no mixed-sex facilities at all, or the only mixed-sex facility is just one accessible toilet. So whilst the interim guidance acknowledges that trans people should not be put in a position where there are no facilities for them to use, it provides no guidance on how employers are expected to ensure, given the limitation of facilities. So there's lots of potential scenarios being debated in the early commentary about issues that this could really give rise to on a practical situation. So I want to throw this one out there as far as a practical issue. What about the case of a trans man who is not known by colleagues to be trans and has been using male facilities without any complaints or questions, and who is now suddenly required to use the women's facilities? It's hard to imagine, isn't it, that the guidance intends that an employer should be required to out a trans employee, particularly one who might have a GRC certificate. That would undoubtedly carry significant discrimination risks. So it's really, this is why I say it's quite unsatisfactory, the position we find ourselves in. What's next steps going to be? Well, full guidance is currently being prepared in the form of a code of practice. We've got, that's expected by the end of July. and there's going to be a 2-week consultation process in May. It's hoped that that's going to cover both employment code of practice and service providers. What should you be doing at this stage? I think you should be seeking to identify what you have by way of suitable third spaces. It's sensible for employers for you to carry out an audit to understand what mixed-sex facilities they have in place and whether or not any additional facilities could or should be redesignated to mixed-sex facilities. In relation to toilets, a simple redesignation of most existing single-sex toilets or unisex is unlikely to meet health and safety executive conditions because there's a requirement there for there to be individual lockable rooms. So our general guidance at the moment is to check facilities to see whether or not they comply. Consider what mixed facilities you currently have. Think about talking to your building consultants or your landlords to find the right balance. Review any policies and handbooks that you've got and make sure that trans people still have facilities. The last point I'd flag, I'm just very conscious of time, is that this case does have further consequences, some actual consequences and some no consequences at all in relation to things like pregnancy and maternity, equal pay, gender pay gap reporting, and where employers have got genuine occupational requirements. I'm afraid I haven't got time to go into those now, but please do. There's a multitude of commentaries out there, but if you want to understand what the consequences of that case for those areas are, please do make sure you read in. Over to Ashley. You've got about 5 minutes, Ashley, for your last case before handing over to Sian.
Thanks, Stuart. So the last case we're going to be looking at today is the case of Gallagher and McKinnon Auto and Hires Limited, which is a case that concerns pre-termination negotiations. So this was a case where the employer had approached the claimant to essentially have a protected conversation with him prior to commencing a redundancy consultation process. And I think this is a really common scenario where an employer is facing a redundancy situation, especially with senior employees, and they tend to approach those senior employees at the start of the process to explain that they're about to commence a redundancy consultation process, but before they do, they would like to have some sort of protected conversation with them. Now, in this case, rather than using the without prejudice label, they decided to rely on Section 11A of the Employment Rights Act 1996, which is an alternative pre-termination discussion route. The difference between Section 11A and the without prejudice rule is that without prejudice, if the label correctly applies, will protect an employer from a variety of claims, but the Section 11A route will only protect the employer against ordinary unfair dismissal claims. For the without prejudice rule to apply, however, there does have to be a dispute in existence or litigation has to be contemplated. As this was not applicable in this case, the employer decided to go down the Section 11A route and offer Mr. Gallagher the redundancy exit package as an alternative to going down the redundancy consultation process. So Mr. Gallagher brought a claim in the employment tribunal and referred to the conversation that had taken place, which the employer then sought to argue was a protected conversation. The tribunal agreed with the employer and said that this did fall within the protection of Section 11A, and that there was therefore, it was not admissible as evidence as part of the tribunal proceedings. On that specific point, Mr. Gallagher appealed to the Employment Appeal Tribunal and stated that he wanted to refer to these discussions because he'd been subject to undue pressure, and that meant that the protection of Section 11A fell away, and so he could therefore refer to this conversation as part of his claim. Mr. Gallagher was trying to argue that the consultation wasn't meaningful because the decision had already been preempted. He'd already been offered an exit package up front, and therefore the company had preempted the outcome and the following consultation wasn't meaningful. The Employment Appeal Tribunal disagreed with Mr. Gallagher and said that the company hadn't put undue pressure on him. So in this case, they'd given him 48 hours to think about the offer, which the tribunal said was absolutely fine. They had verbally presented the offer to him with that 48-hour window, and to the extent he was to accept this, he would have been provided with a written offer. And so in light of this, the judge concluded that the way they had approached this with him did not put him under any undue pressure. They also highlighted in this case that when his employer was making the offer to him, they hadn't said, if you don't accept this offer, you'll be dismissed. The Employment Appeal Tribunal had said that what they had actually said is if the offer of settlement is not accepted, the redundancy process will then begin. And so, again, just another example of how the Employment Appeal Tribunal had come to the conclusion that there was, in fact, no undue pressure in this situation. And so the good news in light of this case is that if you are facing a redundancy situation and you do want to have those upfront conversations with employees, provided that you do it properly, and it must be properly, and you don't put any undue pressure on the employee, you let them know that it's just one option. And if they don't want to take the option of settlement, then they can, of course, go through the redundancy consultation process. And that's a perfectly acceptable way of approaching it with your employees. And that brings us to the end of our case law update. And I'm passing over to Sian to talk about the Employment Rights Bill.
Thanks, Ashley. So good afternoon, all. The last time we were delivering this update in October, the Employment Rights Act was just a week old. And since then, many an hour has been spent digesting the contents and considering how it will impact businesses and what we can do to prepare. It is a vast piece of legislation introducing 28 employment law reforms. And although most of it will not come into force immediately because it requires secondary legislation, the minimum service levels during Industrial Action Act, which the Conservatives had implemented, will be repealed as soon as the bill receives royal assent. That's anticipated to be in July. And some other trade union provisions will come in 2 months later. Everything else is anticipated to come in the next 12 to 24 months. Since October, as the bill has made its way through the House of Commons and then the House of Lords, well over 200 amendments have been proposed and approved. For the most part, they've mainly been clarifications and corrections, but I just wanted to share with you this morning some of the more significant changes. Sorry, we're in the afternoon now. Some more significant changes, with also just a couple of reminders about changes coming up that businesses need to be getting ahead of. So the first one that I wanted to pick up one, and is the major headline of the bill, are the unfair dismissal changes. And what we're going to see is, for the first time ever, the removal of a qualifying period for unfair dismissal claims. So over the years, we've seen qualifying period to be 6 months, 12 months, or 2 years as it is now. That's going away, so that the qualifying period will be 0. It will be a day one right. Now, as it's kind of flagged on the slide, this won't be until at least autumn 2026. It is a big change, noting that many companies use this initial 2-year period to assess an employee in their suitability for the role. And subject to there being no discrimination or automatic unfair dismissal claim, to the extent the employee isn't working out, employers will tend to go through a short service dismissal process, which doesn't follow the full ACAS code of practice in going through first written, final written before dismissal. But it would normally include at least a meeting to discuss their concerns. The Employment Rights Bill provides for regulations to modify the right not to be unfairly dismissed, where a light touch procedure can be followed. This is where a dismissal, however, occurs during an initial period of employment, or where the employer gives notice of termination before the end of the initial period, and that effective date of termination is within 3 months of the last day of the initial period of employment. And furthermore, the principal reason for the dismissal needs to relate to the individual, be it capability, conduct, breach of a statutory restriction, or some other substantial reason relating to the employee. So the government's continuing to consult on what the modified light touch procedure will look like, and the length of the initial period of employment. And they've indicated a preference for this to be 9 months. Now, if it is 9 months, it would effectively allow an employee E to be dismissed right up to the 1 year mark without unfair dismissal liability, provided notice has been given before the end of that initial period and the effective termination date is within the next 3 months. So what do we mean by light touch? Well, I think the good news is that probably what most employers already do as best practice will hopefully tick the boxes, but we don't know exactly what it will entail at this stage. The government has suggested it should consist of holding a meeting with the employee to explain their concerns about performance or conduct, at which the employee can choose to be accompanied by a trade union representative or a colleague. There isn't yet mention of any requirement to write a letter, but I think most employers are likely to want to write a letter regardless, just evidence of your paper trail to the extent there is any future complaint or dispute. And a letter is going to be particularly important where the employee's been uncooperative or absent and doesn't attend that meeting required under the light touch procedure. So whatever this initial period of employment looks like, which is also referred to as the statutory probationary period, employers are likely to need to be a lot more conscientious in following a reasonable and fair procedure from day one, essentially, and then need to understand which procedure actually applies. So managers will need to be supported in this. Training is going to be needed to be provided, and also reviewing your probationary periods to ensure that they are effective. So more details going to follow in the regulations, and it's still subject to further consultation. I just want to flag with the light touch procedure, it will not apply to redundancy dismissals. And so it will be the case from day one that you need to treat all employees who are at risk of redundancy in the same way, whether they're in this initial period or not. What is interesting to note, though, is the bill doesn't change the 2-year qualifying period for your entitlement to statutory redundancy pay, which will stay as a minimum of 2 years service. So inevitably, we anticipate there is going to be a rise in unfair dismissal claims. The reforms also increase the risk, when hiring and recruitment practices are going to have to be that more strategic and robust before new hires are taken on, likely to dampen growth in that respect. And then just also flagging that the Secretary of State will be allowed to specify a cap on what this compensatory award is going to be during the initial period of employment. And so that detail is still yet to follow. So just moving on to extension of time limits to bring claims. Please don't shoot the messenger. So this is probably one of the most significant amendments that was approved, just January time, which the government obviously forgot to include in the initial bill or hoped to sneak it in. I'm not too sure. But it's looking to increase the time limits for almost all claims from 3 to 6 months. And there has been this discussion in the background for some time about increasing time limits, particularly in respect of discrimination claims or where somebody's off on long-term ill health or had a baby, and it can be difficult for them to bring these claims swiftly. It's certainly going to cause more uncertainty for employers for a longer period of time. Some commentary is that it will increase the time to resolve disputes. But equally, your final hearing is going to be pushed back that much further. It's already taken probably the best part of a year to get to final hearing. And by that point, witness evidence and memories are going to fade and people move on. So, yes, I think inevitably this is also going to increase tribunal claims. So moving on to collective consultation. So you'll have heard the hoo-ha back in October when the bill was removing the words one establishment from the test for collective consultation, such that collective consultation could be triggered where an employer simply proposed to dismiss more than 20 or more employees within a 90-day period across their whole organisation. So that impact of removing that at one establishment was going to be really far-reaching for many employers who are multi-site businesses, and possibly making a small number of redundancies all the time. They could have been in perpetual collective consultation. So good news is that proposal has been dropped. However, bad news is that they will be introducing a new trigger for collective consultation, which will introduce a new trigger for collective consultation, looking at proposed dismissals across the organisation. So they're still getting it in there. They've said this new trigger for collective consultation, it can be set higher than 20 employees, and anticipate that will be the case, but they haven't really given us any indication yet on how those redundancies across the business will need to be calculated, and clearly that's going to be critical to understanding what impact this is going to have on businesses. So in terms of other changes to collective consultation provisions alongside this, where employees whom the employer is proposing to dismiss as redundant are not all at one establishment, under the new sections in TOLCRA, employers will be required to disclose in writing to the appropriate representatives the total number of employees it's proposing to dismiss and details of the establishments in which they are employed. Furthermore, with the trigger for the obligation to notify the Secretary of State, there's going to be some alignment here, and where you're proposing to dismiss as redundant 100 or more employees, notification to the Secretary of State will be at least 45 days instead of the current 30 days. Also worth noting, the trigger for consultation about collective redundancies on a TUPE transfer will be aligned with the trigger for collective consultation obligations under this new section. Interestingly, the government has also included provisions within the bill to allow employers to consult appropriate representatives separately on a site-by-site basis, and to consult with a view to reaching different agreements with different groups. So this should help employers where the trigger across the whole organisation is met. Now, the last amendment on the collective consultation, you might want to close your ears, it is scary. The protective award is also going to be increasing from 90 days to 180 days. That's half a year, is massive. Just bringing it to life slightly, if you've got, say, an individual employee who's in their 50s, been with you for 9 years, on £60,000 salary with a 12-week notice period, they're likely, to the extent you don't follow your collective consultation obligations, likely to bring a claim of unfair dismissal. And applying the basic award and compensatory award, the likely maximum for them will be around £70,000. So that's both the basic and the compensatory award. They'll have their 12 weeks notice, so if they haven't been required to work, it's another 15,000. And then the protective award of 180 days. So that's another 30,000 in this scenario. So quite quickly, you know, they could be claiming a minimum of a year's salary, but probably more likely 1 and 3/4 years salary. You add on legal costs for defending the claim, you can quite quickly get up to 2 years salary that they might be claiming. And then you times that by 30 individuals who might be at risk, and you're in your millions. So it will add up very quickly, and it already does add up very quickly to the extent you don't follow your collective consultation obligations. What the government is intending is that it's simply going to just be far too expensive to even buy out employees' rights. It won't be an option. The only option they want is for employers to comply with the law. Many of the respondents to the consultation process have noted that it isn't their desire or conscious decision to not comply with consultation obligations. It's simply the complexity and misunderstanding of the rules. So the bill now contains provisions for the government to issue guidance on the steps to be taken in a collective consultation process. So we await that further guidance. Right, moving on to fire and rehire. So as you know, employers will sometimes need to change terms and conditions, and if employees do not consent, as a last resort, an option has been available to employers to consider dismissing for some other substantial reason and then seeking to engage under new terms and conditions. And this has been known as firing and rehiring. And currently, an employer only needs to act within a range of reasonable responses to be able to fairly dismiss an employee where they fail to kind of agree that variation. The test has been whether the employer had sound business reasons for imposing the change, and the change doesn't have to be crucial to the survival of the business. Well, the provisions of the bill will not entirely eliminate these practices, but it will severely limit the circumstances in which this can be deployed in the future. So under the Employment Rights Bill, dismissal for seeking to or refusal to agree to vary a contract will be automatically unfair unless the reason for the variation was to eliminate, prevent, or significantly reduce or significantly mitigate the effects of any financial difficulties which at the time of the dismissal were affecting or were likely in the immediate future to affect the employer's ability to carry on the business as a going concern or otherwise to carry on the activities constituting the business. That test is set out there in the slides. In addition to that financial difficulty aspect, in all of the circumstances, the employer needs to be able to evidence that they could not reasonably have avoided the need to make that variation. So it's a two-stage test there. And if you break this down, it's a very, very high bar to meet, and improving efficiency just won't come within that exception. So the message from the government is clear that it regards fire and rehire as acceptable only where there's genuinely no alternative. So if you're going to rely on financial difficulties, you're going to want to be able to evidence that financial difficulty. So it's likely to lead to need to instruct in financial restructuring experts to evidence this financial position and other steps that have been considered that weren't available. And inevitably, I think it is likely to lead to more complex and longer hearings and increased costs as a result. It's worth noting, even if the exceptions apply, the tribunal will still need to determine the fairness of the dismissal. You still need to go through a fair procedure, consultation, considering alternatives, what's been offered in return and so forth. It's also worth noting under the collective consultation rules that we've just covered, actually terminating on notice and offering new terms is or does count as a dismissal under our collective consultation obligations. And so if more than 20 are impacted, collective consultation rules will apply. Since January 2025, the ET can also increase a protective award by up to 25% for unreasonable failure to follow the ACAS code of practice on fire and rehire. So make sure that you are familiar already with that code of practice. And yeah, if that protective award is increased to 180 days, this uplift of 25% would be worth another 45 days pay. So yes, I think, or possibly rather depressing, and sadly with the upcoming changes to collective consultation, fire and rehire, let alone the increase to the national living wage, increase to employers' national insurance contributions, Trump tariffs, and just general cost of living, we're not seeing the intended growth. But instead, you know, a lot of the things that are coming across our desk at the moment are where clients are having to review their operations and trying to get ahead of these changes by restructuring now. Just moving on to 0-hour contracts. These have long been condemned by employee representative bodies and trade unions as a means of abusing vulnerable low-income workers and not providing any job securities or rights. And there have been very little protection for these groups of workers. So just as a recap, the bill will add a new subsection to the Employment Rights Act that's going to require employers to offer within a certain timescale, which is not being defined yet, but offer to 0-hour workers and workers with a low number of guaranteed hours, but they regularly work more than those hours, the ability to move to a set number of hours per week on set dates and times. So it'll in essence be guaranteed, giving them more stability. And that will be after a qualifying period and a reference period reflecting the pattern. So we don't know what those periods are going to look like yet, but they're likely to be 12 weeks. And then if actually it arises that they work more hours than what they've been offered over time, then there'll be subsequent reference review period. So this is all under consultation at the moment, and it's worth noting that the bill goes further than just offering these guaranteed hours. There are provisions for workers to be given reasonable notice of change in shifts and compensation for any cancelled or shortened shifts. And yeah, you know, a lot of employers are considering, when we know what these low hours look like, offering more than these low hours to a certain bank of workers. And this is likely to obviously not be very good for diversity, because you're going to offer guaranteed hours or more hours to that pool of more reliable workers. So there's a lot to consider here, and employers have also questioned, well, can we use fixed term contracts? There are anti-avoidance provisions, and that's only going to be permitted where there's a genuine fixed term need. Just flagging in terms of changes since October, so following consultation, it is the case that agency workers are also going to be included within the scope of these provisions, with the responsibility falling on either the hirer, the agency, or both, depending on which provision you're talking about. And this is going to impact employers that use agency workers on a more regular and longer term basis. And certainly there'll be a need to review agency agreement terms and look at possibly alternative options. Also noting that there have also been amendments to add in a requirement for employers to take reasonable steps to provide information to workers on what their rights are under the bill. Still on 0-hour workers, there's also a new requirement being added for employers to give notice if they think one of the exceptions under the bill applies. Provisions have also been included to enable workers to bring claims in the ET for breach of these new duties. There is an option to exclude the provisions via a collective agreement, but only if these provisions are replaced with something else and the terms are incorporated into the contract with the worker. So yes, long and short is that, you know, employers that do rely heavily on 0-hour workers are going to need to familiarise themselves with these regulations to ensure compliance, and possibly look at how they revisiting how they engage staff. Just then touching upon harassment, you'll note that since October 2024, there's a duty on employers to take reasonable steps to prevent sexual harassment, and the EHRC published its guidance on what it considers reasonable steps and guidance to support employers. But Labour didn't consider those changes went far enough, and the bill will include a new duty to take all reasonable steps to prevent sexual harassment of employees, including any third parties. So this is going to be the onerous one for employers. The regulations, which we're yet to see, may specify what's regarded as reasonable steps, but it's likely to mirror the existing concept of reasonable steps defence, which we've set out in the slide there. It is going to become a lot harder to successfully defend a sexual harassment claim, and employers will face both financial penalty of an uplift to the employee's compensation and potential investigation by the EHRC resulting in enforcement action. It is third-party harassment that's of particular concern to employers, because it doesn't require the employer to have knowledge of the harassment. There's no requirement for it to have happened before. They'll simply be liable if it's happened during the course of their employment, and you or the employers failed to take all reasonable steps to prevent such harassment. And as we know, it's hard to control the actions of our employees, let alone third parties. And yeah, where you're in an industry that's particularly customer facing, hospitality, retail, or so many industries, you're going to need to invest a lot of time in assessing and trying to mitigate against this risk. It's also worth noting that it will be a protected disclosure for an employee to report sexual harassment having occurred. So the significance of that is that any contractual terms will be enforceable insofar as they try and stop an individual making a protected disclosure. So disclosures about sexual harassment can't be excluded within the scope of confidentiality provisions in employment contracts, service agreements, NDAs, and settlement agreements. You're also going to have to possibly look at reviewing your whistleblowing policy, and then make sure that sexual harassment complaints are investigated within it, as they will fall within the scope of your policy. Finally, just touching upon flexible working and the changes coming up here. You'll have seen the changes that came in just last year, but what the bill will now also do is introduce this new test of reasonableness when refusing a flexible working request. Whilst it won't make flexible working the default position and individuals still need to make the request, it is going to make it harder for employees to refuse a request and likely result in more tribunal claims where it's declined, due to the introduction of this reasonable aspect of the refusal. It's worth flagging they haven't increased or changed the compensation limit for failure to follow the flexible working rules. It's still going to remain 8 weeks pay. So there's some argument that the statutory scheme lacks real teeth, but an individual never brings a claim just for failure to comply with the statutory rules on flexible working. They'll always inevitably bring a discrimination claim as well, and to the extent they resign, they'll claim constructive dismissal as well. So there are always additional claims in addition to the flexible working claim that we receive. So it's really important that now you deal with flexible working requests reasonably and have objective evidence to support any refusal. So that's a quick whistle-stop tour. Did note at the beginning there are 200 changes. There have been a lot of changes on trade union rules and also umbrella companies. So to the extent that's you do need more information on that, please let us know. My only final watch out for today is also just flagging the need or obligation that's going to be on employers to keep adequate records to show that you've complied with your duty to provide statutory holiday and pay to your workers and keep records for 6 years. Yeah, there are some businesses that stick their head in the sand in relation to this issue. It's on the too difficult pile. It needs to come to the top of the pile to the extent employers aren't paying holiday pay correctly. And now's the time to do an audit and make sure that we get that right. So yes, I think it's safe to say there's a lot coming down the track at the moment, and we appreciate it can be quite overwhelming, but do let us know if we can support. I think we're now going to go over to, with what time we've got left, answering some of your questions.
Fantastic. Thanks, Sian. Yeah, I don't think it's going to be quiet times, is it, if you're an HR professional or an employment lawyer? Pipeline is going to be interesting. Yeah, we like to be responsive, and I think the team at Ciphr had encouraged questions to be asked. Quite a lot of the questions that were asked we've sort of built into the session already, but there was 3 in particular that we're going to deal with, and I can see that Antonia's keyboard's been smoking while we've been presenting, but I'm just going to quickly go through the 3 questions that were raised specifically that didn't naturally fit, I suppose, into the presentation, and then we can see if there's any other further last-minute questions that we can build in. So the first one was, what emerging trends are you seeing with regards to work that's landing on your desk, particularly with regards to redundancy scenarios? I think, as I touched on when I was talking about the Carnival case, we're seeing a real spike, unfortunately. We say that in relation to redundancies. Whether or not that is small or medium or even collective. I speak, we are a big team here at Shoosmiths. There's nearly 60 of us nationally. We have regular catch-ups, and what my local team here is seeing is replicated up and down the country. And so we are probably advising on as many collective redundancy situations as we have done for a while. Personally, I'd probably describe the two that I'm advising on as being the sublime to the ridiculous. Sublime one being where the clients have got a nice big HR team and appreciate from day one about how much preparation is needed before you press the button and go down a collective consultation process, to another lovely client. But we had a first call on a Friday, a long call on a Monday, and we announced on the Wednesday. It was an interesting weekend, let's just put it like that. But yeah, so unfortunately we're seeing a real spike. The second question was, what are the limitation periods that apply in relation to employment-related claims? There was a sub-question there as well, in relation to how long individuals can claim holiday pay or backdated holiday pay claims. So it's a difficult question to answer. Simply, generally speaking, the bulk of employment tribunal claims need to be brought within 3 months. If that's an unfair dismissal claim, that's within 3 months of the date of dismissal. If it's a discrimination claim, it's within 3 months of the last date of discrimination or last act of discrimination, bearing in mind the fact that employees can argue that there's a series of continuing acts that can prolong the limitation period. That can get complicated because employees have to go through the ACAS pre-claim process to get their ACAS certificate before they can issue, and that can make things a little bit more complicated with regards to determining exactly what the new limitation period is. And in relation to, the other things to add, breach of contract claims, depending on the form in which they're brought, limitation period there is 6 years. And how far can you go back in relation to unpaid holiday pay claims? By and large, the long stop date that an employee can go back is 2 years. There are some very rare occasions when an employee can go back 6 years, but by and large, it's 2 years. And last but not least, and I might throw this out to the floor with my co-presenters about which policies are we getting most requests to review at this current time. I'll put forward a couple by saying sexual harassment policies, redundancy. I think, Sian, you've seen a number of others. Was it you were mentioning hybrid working?
Hybrid working, yeah, there has been probably a bit of a shift in the last 6 months, I think, with more companies wanting increased office attendance and needing to make sure their hybrid policies are, informal, flexible, subject to business needs. For employers that haven't updated their flexible working policies given changes last year, they certainly need updating as well. So we have seen those, and we've seen a increase in flexible working requests generally already. Sickness is always one that continues to haunt a lot of employers, particularly where they've got kind of generous company sick pay provisions. So we've seen, there's always kind of requests for reviewing of time and attendance policies and absence management policies. Don't think that's ever going to go away, but just to tighten them, particularly when individuals are going overseas. What other policies? That's probably about it. Yeah,
I think that's probably it. Yeah. Okay. Antonia, was there anything that we didn't capture on your questions, or was there any particular question that you thought that everyone would be really interested in hearing the answer to?
Well, we've had quite a lot of questions around when these provisions under the Employment Rights Bill are going to come into force. And that is the $1 million question, isn't it? So what my understanding is that when the bill receives royal assent, which, as Sian said, we're expecting it to be around July time, once it's passed through the House of Lords. The first thing that happens is that they will repeal the minimum service levels for strike action, which was an act that the last government brought into force. And then about 2 months later, some of the trade union provisions will come into effect. But all the other provisions under the Act require implementing regulations to bring them into force. And the government has promised to consult in relation to a lot of those implementing regulations, so particularly around things like the 0 hours, low hour workers provisions. So we really have no idea when they might come in. We're expecting consultations to be launched kind of latter half of this year, and we will start to see the changes coming in from next year. And the government have said, certainly for the unfair dismissal, that will be autumn next year. So it's a bit of watch this space, I'm afraid. The only other thing I was going to just quickly flag is in relation to the 0 hours, low hours work. So it will apply to anyone who becomes a qualifying worker. So we've had a question about whether it would include casual worker agreements. There's potential. It depends whether the individual fits within the definition of a qualifying worker for the purposes of the bill. And again, we're going to get more detail around who is a qualifying worker in regulations when those are set out for consultation. So again, it's not a straightforward answer, as most of the things in relation to the Employment Rights Bill are.
Thanks, Antonia. The time is 5:16. I don't know if any of the team from Ciphr want to come back in.
Yeah, we're here. I've got my glasses on. I've been reading those case law slides intently. Thank you so much, Stuart, Sian, Ashley, Antonia, for giving us such a comprehensive lowdown of the case law and everything that's on the horizon with the Employment Rights Bill. There is so much there to digest, and I know lots of people in the chat have been asking about the recording. That is coming your way as soon as we can, possibly today, more likely tomorrow morning. So you can revisit this and share it with colleagues as you need to. And of course, the Shoosmiths team are there. We had their contact details on screen. If you want to reach out for more advice from them, you can do, or you can use the exit survey at the end of this broadcast to opt in for more information from Shoosmiths and indeed from Ciphr. So if you want to look at any more of our solutions, feel free to let us know and we'll happily set up a demo for you. So thanks everybody at Shoosmiths, and thank you, Amanda, for joining us today. We do appreciate your expertise and knowledge as always. Thank you everyone for joining us live today and sending in so many thoughtful questions. We appreciate you joining us. Look out for that recording dropping in your inbox shortly, and we hope to see you at another webinar again soon. Take care and have a great rest of your day. Thank you. Bye.
Thanks. Bye.